In our daily life, we come across the individuals and the married couples who spend their lives happily. But sometimes individuals and couples can feel dissatisfied, unhappy, and unfulfilled in their marriages, relationships, and be unsure as to what exactly is wrong. And then the question comes up in their mind that their marriage is a question and they are facing a real dilemma. So they think of divorce. But the main question is, when can we file the divorce petition? How much time is necessary? What are the requirements to be fulfilled for filing a divorce petition? Hello everyone. From the last few videos, I have been discussing the Hindu Marriage Act 1955, and by the time I have explained 1 to 13 sections of the act. So in this video, as I introduced above, I'll discuss section 14, and in the part 2 of this video, I'll discuss section 15 of the Hindu Marriage Act. Section 14 talks about the time period, that is, when the petition of the divorce can be filed. As time is an important element in our life, the same way the time period in the legal field is also equally important. Along with section 14, in my part 2 video, I'll make a little effort to make you understand section 15, which talks about when the divorced person can marry again and also will put light upon the conditions which needs to be fulfilled by divorced person for remarriage. So, first let's check out what section 14 states. Notwithstanding anything contained in this act, it shall not be competent for any court to entertain any petition for dissolution of a marriage by the decree of divorce, unless at the date of presentation of the petition 1 year has elapsed since the date of the marriage. Don't get confused with the lengthy sentence. I mean, section 14 of Hindu Marriage Act, it simply explains no court shall entertain a petition of divorce before the expiration of a period of 1 year from the date of the marriage. We will understand with the help of an example so that you will get more clarification. If the person, namely Mr. Soham, married on March 5th, 2020, then court will not accept his petition for divorce until March 5th, 2021. Or in other words, Mr. Soham's petition for divorce will be considered only after completion of 1 year, that is, after March 5th, 2021. I hope it is clear now, right? This period of 1 year has been changed with the prior to the amendment of 1976, where the period to entertain the petition was 3 years, which reduced to 1 year. However, another important point that you should keep in mind is under section 14 itself, the court has power to entertain a divorce petition even before the expiry of 1 year in cases of exceptional hardship to the petitioner or exceptional depravity of the respondent. Court also has the power to dismiss the petition if it has been obtained by misrepresentation or concealment of the facts. So, in case of filing of divorce petition before the completion of 1 year of marriage, it is the discretionary power of the court to accept it or to reject it. So now we'll understand the main object of section 14 with the help of case law. In the famous case of Meghnata Iyer versus Sushila, the Madras High Court observed that section 14 it provides restrictions presumably designed to prevent party recourse to legal proceedings before the parties have made the real effort to save their marriage from disaster. It means such restrictions it's put only to those couples who did not try to save their marriage by any other means. Further, it is grounded on public policy because marriage is the foundation of civil society and no part of the laws and constitution of a country can be more vital importance to its subjects than those which regulated the manner and the conditions of forming and, if necessary, of dissolving marriage contract. So, the main object of 1 year period of divorce petition is to save the marital relationship. In addition to this, under Section 14, Clause 2, the court must have regard to the interest of the children born of the wedlock and the question whether there is reasonable probability of a reconciliation between the parties. See, even when the relations between the spouses may be strained and there may be no immediate prospect of reconciliation, still the interest of child it should be given the paramount consideration. In the field of matrimonial relationship, a purely mechanistic and the formal approaches is not called for. One has to view and perform this task in a broader perspective. So this is all about section 14. Hope you understood it clearly. For any queries or any more questions, you can comment in the comment box given below. Thank you.